Good morning again. And now, for the business at hand, we have one matter on today's calendar, which is Kahn versus Yale University. Each side will have 30 minutes to argue. The appellant may reserve any portion of that time for rebuttal. Counsel, you ready to proceed? Please identify yourself for the record and let me know how much time you would like, if any, for rebuttal.
Thank you, Chief Justice Robinson. My name is Norm Pattis. I represent Saifullah Khan, and I would like to reserve 7 minutes for rebuttal.
Thank you, counsel. Whenever you're ready.
I would like to thank the court first for agreeing to reschedule this argument, given the circumstances that arose. I really appreciate it. And I'd like to apologize to you all, including Justice Keller. I didn't realize there was a special proceeding. I just came in, got locked down, and didn't look up until it was too late. So.
It's quite all right, counsel, and no apologies are necessary for the rescheduling. You probably remember when you tried cases before me before. I remember what it was like to be a litigator and having to be in two places at one time, so no worries.
Thank you, sir. So, it's hard to know where to begin here. The Second Circuit sent us 7 questions, and I think I'll deal with an easier one first and then jump into what I think are more difficult issues. You can make short work of this by concluding that there is a state action requirement for quasi-judicial review. And I think that might be inconsistent with the tendency that this court is adopting to embrace what I would regard as a more functional test about what quasi-judicial review or quasi-judicial immunity entails. But I think there would be good policy.
Mr. Pattis, but I had a short discussion with Justice Eckert this morning about this case, and it seems to me historically that hasn't been the case.
Well, I look back to the 1890 decision that Peyton v. Ellis, reversed, and historically this immunity was limited to legislative proceedings, judicial proceedings, and established courts of justice, and then there were some military proceedings listed as well. And I think in each of these cases there was a sense that what we were protecting was the dignity of the court, and that before an immunity could be granted, something powerful had to be evoked. And so a private administrative proceeding wouldn't work. In Peyton v. Ellis, that rule was relaxed, but not to the derogation of the state action requirement. I believe Peyton v. Ellis arose in the context of the Department of Labor and an administrative agency. So again, this was the law fact issue, which is a second related issue. But in each case, the body before whom a declarant testified was charged with making determinations of fact based on existing law from the state, or law enacted by the state. And so in order to evoke quasi-judicial immunity, it seemed to me that there was an implicit state action requirement. To say otherwise would be to say whenever something looked like a court, or whenever someone's interest on a strict functional reading, on the 6 powers, as it were, on a strict functional reading, anybody could do that. Anybody, not anyone, including a drunken bunch of frat boys or sorority sisters. And I don't think that's a road that this court wants to travel down.
Counsel, under your interpretation of state actors, would UConn be a state actor?
Yes.
Where's if the proceedings would be identical at UConn or Yale, why does the private-public distinction, why does the distinction between private and public turn the entire process upside down?
I'm not sure that the proceedings would be identical. And so I'll assume that for purposes of answering your question. If they're identical, then they're identical for a reason. And I think this court would have to inquire what that reason is. If a private entity adopted a state regulation or relied on it, as Yale does with respect to 10A55M and the affirmative consent decision, then I think it cloaks itself in that, and that presents this court with some difficulties. And I agree that it appears to be inconsistent. But in that case, the private actor is adopting state policies and procedures to the derogation of my argument. And so
my understanding is that the procedures are very different at different universities. I read that I don't think in the briefs, but in law review articles, that they're very different. And that, I mean, this is the fundamental, the due process clause applies to public schools and not to Yale and private schools. Isn't that the fundamental distinction?
Well, yes and no. And what this litigation was, and so I agree with you that what Title IX imposes is adoption of a regime, of a publicized regime that is consistent and addresses certain policy factors. But our contention in this...
But I mean, I think that the law is pretty clear, and if Yale were here, I think it would insist that it is not engaging in state action in this or any other endeavor. It is not a state actor. And I think that there are cases that say that private universities are not state actors. They don't have to respect the First Amendment. They don't have to respect the due process clause. They can if they want to, but they don't have to.
Well, that's where...
And I'm not sure, I mean, you can argue against me. I sort of see that point as strongly supporting a public-private distinction in this context.
You know, if I thought I had 5 of your votes on that, I'd sit down and shut up. But candidly, as I struggled through the issues in this brief and the remand and in preparation for this lawsuit, I just don't think it's that simple. I think with respect to the emerging Title IX litigation, and this suit, by the way, is drafted with an eye toward the Fifth Circuit, and where the decisions are applying due process considerations to private actors because of the Title IX requirements. And so the cross-examination right, for example, the in-person cross-examination right was first recognized in the Fifth Circuit. The Second Circuit seems to be breaking our way. And so it seems...
You didn't make a claim against Yale violating the due process clause. It was a contract claim.
Under Title IX.
I understand, but
so
Title IX doesn't trump the due process clause, right?
No, but we say it incorporates the requirements. And so the game, as it were, that's being played is how many times can a plaintiff persuade a circuit court or a Supreme Court to apply the protections that typically obtain in a criminal case to the Title IX requirement, cloaking the university in something like a state action requirement. And I think this goes to Justice McDonald's point, where the standards may begin to look the same. And there may not be a distinction with difference there in a Title IX context, which is why in response, in the supplemental brief that you asked us to write, in response to the prior decision, I'm not sure I'm pronouncing the name correctly, or if it's prior or priori, or a priori, but, you know, it strikes me that the best course for this court to go would be to recognize this immunity not as absolute in character, but qualified. Because there are so many factors that a reviewing court includes.
Can I ask you about that? I'm curious about that. How would we recognize a sort of qualified immunity if we don't first decide whether this is a quasi-judicial proceeding? Can that be done? Do we need to decide whether it's a quasi-judicial proceeding first?
I think the trial court needs to make that decision and let the parties duke it out, as it were, and present you with a complete record. I don't think you can make that decision strictly on the briefs. I mean, we've urged you to do so in our brief, but I take Justice McDonald's, you know, point in the as I read priori, the majorities, you know, said there was no absolute qualified immunity in the limited context of that holding. And then the concurrence went on to say, don't get too excited, plaintiffs bar. There are factual circumstances that matter. And so what that told me as a litigator is if I'm going to rely on this body of law, first of all, I want a body of law to shoot at. So what do I want to be able to say to a trial court? Regardless of whether the actor in this case is public or private, there are these 6 powers. And there are certain limitations on how these powers can be exercised. And in a case where a plaintiff challenges the efficacy of the institutional arrangement, as we did in Yale, we think that the decision on immunity cannot be reached until the fact finder has a complete record on what they're looking at, whether public or private. Because it struck me, looking at the cases that this court, the public-private, I mean, I may clearly misread you, Justice Ecker. I think I did. It didn't strike me that the public-private decision was a hill that this court was prepared to die on. And as I looked at the cases, the 6 functions test or the 6 powers test struck me as incredibly more flexible. But then the question is, how do you apply that? And it struck me that the best way to go would be to shift from absolute immunity based on a cold record that's unchallenged. And in those cases where a plaintiff chooses to challenge the proceeding, if necessary, let the plaintiff seeking immunity have the proceeding stayed until the court has a complete record before it.
Sorry.
Go ahead.
What's the, give me an example of something that the district court, if it went back to Judge Dooley, you'd be looking for that court to flesh out? What needs to be fleshed out there?
I think the very issues that we pled here, for example, there was no ability to confront the witness in person. There was no ability to have counsel represent.
But that's admitted.
There was no ability to have Mr. Kahn. All these factors are admitted, but do they matter in this? Do they matter in this context as a whole? But
you think that would be subject to fact finding? What would Judge Dooley be making findings about, like how critical it was to the proceeding?
Yes. And so, one of the reasons I wanted to handle this argument myself is I was involved in every stage of the proceedings below. Personal confrontation mattered incredibly in this case. This was a case that was terrifying to read about on paper, but not too terrifying to deal with in a courtroom, where the ability to confront a witness and assess their body language, their demeanor, their face, to challenge them on inconsistencies and say to a fact finder, look, you're prepared to do all this with respect to that? And with respect to every LIO down to sex 4, the jury acquitted in a matter of hours, because I think personal confrontation mattered. With respect to the state action requirement, I'm going back to Justice McDonald's point, we argued in our brief that this first factor, the non-governmental entity factor, was in part a state action requirement, but in part a judicial review requirement. In the Yale context, we have a tremendous problem, because when Mr. Kahn asked for transcripts of the proceedings so that he could perfect appellate or administrative or some other sort of view, they gave him no transcript.
But counsel, my concern, I guess, is not the facts as it is applied to the process. It's the process itself. So are you suggesting that the determination about whether an entity is a quasi-judicial entity is a factual question, not a legal determination?
I know how much justices and judges hate when a lawyer says it's a mixed question of fact and law. But I believe that. I think the easy route would be to adopt a categorical rule that says if it's a private entity serving its own purpose in an untethered way, not applying law to facts, then it's not a governmental entity. And the long tradition, historic tradition reaching back into the 19th century of a limited application of immunity should apply. But I don't think that's the direction the court's moving in.
I mean, given what we know in this record about the process used by Yale, why isn't that sufficient for the determination about whether or not it's a quasi-judicial entity?
Judge Dooley has ruled. I mean, again, the procedural posture of this case is as follows. Preliminarily, Jane Doe was let out. We took the appeal. The underlying action as to Yale was stayed. So at most, we have a district court decision on an issue that we think the Second Circuit or the United States Supreme Court will have to decide. And that is whether the Second Circuit will follow the Fifth as to the scope of cross-examination rights and whether the failure to order the transcript matters. So I would say that if this was a completed record, in other words, we've gone through summary judgment as to both parties, that might be a different factor, because on a cold record, I can't demonstrate the harm that befell my client by failure to have personal confrontation rights or the right to counsel.
Well, but there's nothing, as I understand this record, there's nothing in the policy or process that affords your client cross-examination.
And that's the exact, that's the issue.
Well, but is that a factual issue that needs to be determined, or can we not read the process itself and by the plain language of that conclude that there's no right of confrontation?
I don't know, we're stuck between the Second Circuit and the Connecticut Supreme Court. The Connecticut Supreme Court has the final word with respect to what the common law privilege applies. The United States Supreme Court will have the final word on what Title IX obtains. We've got a partial judgment here, and I think I'm in an awkward position where I haven't had the opportunity to fully and fairly litigate the Title IX claim, which we which we think we're likely to win. But yet I'm pleading for the right to hold this young woman in the case. This is why in the supplemental brief I urged a qualified immunity regime with a stay as to this person, because when there are serious questions about the proceedings, I think I'm prejudiced otherwise.
What about, Attorney Pattis, on the same line, the complainant wasn't put under oath, is that right?
Yeah, that's a huge problem for us.
But we don't need facts to determine that. We know that, right? So in terms of seeing what this process was or what it requires and whether it's more like a judicial proceeding or not, or quasi-judicial, you got no cross-examination, you got, she wasn't put under oath. These are things I don't think we would need facts about or to determine how that affected
I don't want to give away too much in my argument. That would, in my view, if the court could take those factors alone and say this is non-governmental, because in no other circumstance would a person's interest be placed in peril without somebody being placed under oath. There was we have no leverage over the declarant in that case. We can't even make a claim of perjury because she wasn't sworn. So if anything, Justice Mullen, that would support the claim that I'm entitled to all the relief that we seek on a non-state actor thing.
Attorney Pattis, I'm sorry, one of the things that troubles me is I'm not sure how neutral the panel can be when Yale officials helped the complainant draft her complaint. When if they don't conduct proceedings in accord with Title IX, they can lose funding. Is that correct?
Yes.
So I think one of the things that bothers me is I'm not sure how neutral the panel they have a fact finder, a hired fact finder who actually presents them with facts and recommendations.
In some instances, yes.
And who is that person? Is that a Yale employee?
I don't recall in this case. I recall in another, it was retired Judge Hodgson. So usually they'll go outside of the university.
Because, when you look at quasi-judicial proceedings, most of the time the fact finder looks fairly neutral to me. Mm-hmm. Doesn't have anything at stake in terms of what occurs. Here they can have a complaint brought against them if they don't handle it well. They can lose Title IX funding if they don't follow the Title IX regulations. Is that correct?
Yes. So, all of which argues in favor of a position perhaps that I'm conceding too easily here, that they are not a governmental entity, that there are no assurances of reliability, that the context should drive the conclusion that there can be no quasi-judicial immunity. Having said that, Justice Keller, I'll concede as your officer, the public policy rationale about wanting to get truthful testimony and protecting declarants is important, at least to
Well, if there were some kind of, usually because they're under oath, we can always say when we grant absolute immunity that there's the penalty of perjury, keeps the person honest. But in this case, it would have been, I don't know what the penalty would have been if they had determined that the complainant wasn't being honest. She was already graduated, correct?
Yes.
So they couldn't discipline her in any way as a student.
Well, our view is that there was no interest in doing that whatsoever. Although it's highly fact-specific, the manner in which Khan was pursued post-acquittal in the criminal case suggests to us a tremendous animus against him.
She had graduated also, so I guess they could retroactively take away her diploma, but she was not within the school's jurisdiction for any other purpose. I don't know if that's unique to this situation, if it's unusual, that is.
So what was unique here,
or if it's routine that these take enough time that the complainant may be gone. If it's a senior, I suppose, I don't know what happens.
I think Yale gave Mr. Khan something that they will unlikely give another student. When the proceedings first arose, we were involved, and it was obvious that this was heading to the criminal courts. He was dispossessed of his room one night by the Yale police, and so we asked for a stay of the administrative proceedings pending the outcome of the criminal case, and I believe it took a couple of years to get the case to trial. In my experience with young people in the Title IX context, you almost never get a stay. And so I think it's another one-off factor that may be unique to this case and accounts for her not being
Well,
excused.
would you have any problem with a qualified immunity, a qualified privilege? I mean, when we say qualified immunity, we usually think of state actors. But there's a qualified privilege in other defamation contexts that has nothing to do with who's saying the thing, who's saying the words or the context.
No, we think that's the right
So
outcome.
I'm just wondering, I mean, because that would require a malice finding, but you've alleged malice.
Correct.
And to win, I think you have to prove malice.
Correct.
So probably. What about a qualified? And there was much briefing on a qualified privilege, and I'm just wondering about that. Did Judge Dooley make any? Was that in the case until the Second Circuit touched it?
No, not in any real way. And it wasn't until I read the concurrence in priority that I thought that was probably the right outcome here, because it strikes me that the line between state and non-state actors, to my mind, was not entirely clear. The 6 factors, those are important, but you don't need to prove each and every one of them. I think a qualified privilege makes sense, but the issue as to Yale's compliance with Title IX has to be resolved first, in our view. Now, that leaves open an additional question.
Well, that's not before us. I mean, we just have the privilege issue.
Well, yes and no. I mean, you could conclude that a qualified privilege is appropriate, but the factors needed to address it require a more complete record as to the institution, because the context matters. I don't think this is something that can be decided.
I'm just saying it's not really a Title IX question. I think we're being asked whether there's a common law privilege that are applicable to these proceedings. Now, the fact that, Title IX and this Connecticut statute is implicated may affect whether there's law, whether, that kind of thing, but
I think there's an overlap between the Title IX and the common law privilege. You could find a situation where Title IX was violated, but the person was nonetheless entitled to the privilege, or that you could find the converse. We think that we should be able to develop a complete record before the question of privilege is addressed, and we would prefer
Title IX doesn't speak to a defamation claim. I mean, and neither does the state statute. They don't say anything about. I understand that you've got Title IX on your mind, and that's a federal issue. And I mean, I just wonder what it has to do with deciding whether or not this court is going to deem this kind of proceeding to be subject to an absolute privilege or something less. I mean, unless you think the statute requires an outcome one way or the other, or bears upon the outcome one way or the other.
No, I think that the question of, well, I mean, I may not be understanding your point, Justice Ecker, because I just don't think the privilege issue can be reached until the other issues are resolved. And given the way this broke, if it's an absolute privilege, then presumably it can be decided on the papers. But if it's qualified, we should have been given an opportunity to develop that record as against Yale, and we haven't had that yet. And we think that until we have that, there's not, we're prejudiced by that. And now, look, it's cost us 2.5 years in litigation to go to the Second Circuit on Jane Doe, to come here, we await your decision, all of which then it goes back to the Second Circuit for a remand back to the district court, and we start the litigation all over again, hopefully with Jane Doe.
Did you request an evidentiary hearing when the motion to dismiss? I mean, under state procedure, you can request an evidentiary hearing when a motion to dismiss is filed. Were you able to do that?
We did not, and I don't believe we were.
Okay.
Thank you, counsel. You have your 7.
Good morning, Your Honors. I'm Jim Sconzo, along with Brendan Gooley. I represent Jane Doe. Congratulations, Justice Keller.
Thank you.
May it please the Court, Attorney Pattis, pleased to be here today. I'll jump in on the state action requirement and address some of the issues that were just raised. Let me first say...
Counsel, I have a baseline question for you. You represent Jane Doe?
Yes, I do.
Only Jane Doe?
Only Jane Doe.
Who's representing Yale University?
Pat Noonan.
And they have no stake, I mean, there's no brief filed by Yale in this case?
Not in this
They take no
case.
position on any of this?
I think they're supportive of this, but they have not filed a brief in the matter.
Thank you.
Yep. So Justice McDonald, you asked the question to Attorney Pattis about whether this is this question of state action of quasi-judicial immunity is illegal or a mixed fact question. I think Your Honor wrote the opinion in priority, and you stated that it was a question of law. So I think there is enough in the record now, and I don't see what sending it back to Judge Dooley would enhance in terms of Your Honor's consideration of the question of whether or not quasi-judicial immunity should hold here.
Well, I thought about that. I have a lot of questions about what happened, but unfortunately we have no record of how the hearing went down. And all we can do is look at what everyone sort of agrees on, or look at what the procedures are, I suppose. Do we have in the record the actual Yale procedures?
Yes, we do.
Okay, so
They
we
are
can
in
look
the
at
record.
that, and we know for a fact that no record was kept. We know for a fact that even though certain questions were posed to the panel, they didn't have to ask the questions that either party wanted to pose to the other. Is it a fact that certain questions that Mr. Kahn wanted to pose to the complainant were not allowed by the panel?
We don't have a record.
We don't know that,
Right, we don't have a record of that.
But that could happen, correct? So we can assume that.
We can assume that.
So I suppose we can look at and assume the worst-case scenario with respect to the procedures in terms of Mr. Pattis's claims of lack of due process, correct?
You could assume some of what Mr. Pattis argues, but the record...
She didn't appear. She was...
well, she did appear.
Well, remotely, correct?
Correct.
Was it a video or was it a phone?
It was remote. I can't say more than that. That's the record. But the UWC process, which is in the record, Justice Keller, is extensive. And I would...
Does the process, does Title IX actually say you must have these certain things? In other words, some of the due process protections that, does it actually state the following due process protections must be afforded? Or is it very loose and broad in terms of what's required so that each school can basically do its own thing?
I think it's a little of both. So Justice Ecker said in reading law review articles that every school seems to do it different. And I would think that that's true, that there is nuance imparted in what the Department of Education has said in its guidance and now regulations under Title IX.
What does it say about suspending somebody before there's even been a hearing? Is that okay? Is that recommended by Title IX, or is that something the school decides?
That's decided by the school. It's permissible if it's in the school's contract with the student. That's completely permissible.
I'm interested in Justice Keller's, a couple things. One of them is Justice Keller's question about, I mean, it's counterintuitive to me that it's a judicial entity or function at all. I mean, you know, all kinds of private institutions do all kinds of decision-making, applying whatever rules there are to certain facts with employee discipline and so forth. Sometimes they're in regulation, and statutes require certain things that be done in terms of quality control. But, you know, this immunity is about respect for a government process, whether it's a court or an administrative body or some government process where the law says, hey, let's draw a circle around that and put a fence up around it, and we're going to allow that process to play itself out without allowing collateral attacks by defamation cases. Yale is not a governmental entity. It has none of the interests of a governmental entity, particularly in terms of neutrality, and that's what I want to ask you about. I mean, for better or worse, and it may be for better, my impression is that places like Yale generally have a very strong incentive to make this process as friendly to the complainant as possible. And I don't know if it's appropriate, if it's to say this, but it seems to me, they need to attract women as students, the best women they can get. And women aren't going to go to a place that advertises itself as friendly to people accused of sexual assault. Women are going to go to a place, if I were a woman, I would think, that takes those complaints seriously, especially if their statistics are right. Yale wants to attract those people, and Yale has a strong interest, it seems to me, in developing a system that is as complainant-friendly as possible. Because that's they're selling, that's what the consumers want.
Well, Justice Ecker, I think Yale, like any institution, has an interest compelled by federal and state law to have a gender-neutral policy, and that's what this policy is. It's gender-neutral. But to get more to the point of why
well, it's on its face, it's gender-neutral, but it applies mostly to, I assume the statistics are mostly it's women, not all, mostly it's women complaining about being sexually assaulted by men. And, let's be real. Now's the time for that. Is it not true that Yale has a particular interest in making itself as attractive as possible as a place to go to school for female women, for female students?
That may be true, and I'm not here to argue Yale's position in this matter. I'm here to argue...
But how is that neutral, if that's its interest?
The policies that are before this court are neutral. They're neutral in their terms and their application, and they were neutrally applied based on the record in this case. And what I would say to the private-public distinction is we are not standing before the court asking this court to apply quasi-judicial immunity in a case that isn't compelled by law. So to use Attorney Pattis's drunken sailor analogy, that's not the case. Or Your Honors...
You're not compelled by law to not allow cross-examination.
We are compelled by law to have this. We did allow cross-examination.
You're not allowed by law to not administer an oath. You're not required by law. You're not compelled by law. Are you compelled by law to follow Title IX if you decline federal funds?
But Yale...
I know Yale wants the money, but it's compelled in that sense. Now, it is compelled under 55. I understand that, but you're going to have to do better for me than that.
But there is cross-examination. It may be not as Mr. Pattis would have expected in a criminal proceeding.
You can't tell us on this record whether a single question suggested by Mr. Kahn or his lawyer was asked of the complainant. You can't tell us that.
What I can tell you is this, though. What I can tell you is
that true or false? I think that's a fair question.
I'm not saying it's not a fair question. I'm thinking about...
Well, what's the fair answer? What's the correct answer?
Is that you are probably correct on this record. But what I can tell you, though, in that regard, is that the process starts with a complaint, which Mr. Kahn is provided with. He's then allowed to provide whatever information he wants in response. Justice Keller, to your point, a neutral, not employed by Yale University, a neutral fact finder is engaged and was in this case. That person
does a Yale employee also help the accused fill out his paperwork?
Absolutely. It's totally neutral. He would have the same resources and support. It's bilateral.
Counsel,
available either way.
Let me ask you, as I understand it from your brief, the plaintiff was allowed to submit a list of witnesses. It's not his determination about whether they're actually called, though. Right? The panel or the fact finder gets to determine whether the witness is relevant. Can you give me another...
In part. There's two, I think we may be merging two parts of the process, and this is what I was trying to step through for Justice Ecker. There's 2 points in this process where Mr. Kahn is fully heard. One, Justice McDonald, is in what you're talking about, the fact finding. In the fact-finding process, it's a robust uncovering of facts where an independent fact finder fully hears out everybody. Witnesses, Mr. Kahn, looks at exhibits.
Who is it?
It's
Is it a private attorney?
It's a private trained
And who pays the
attorney.
private attorney?
The university.
Okay.
Counsel, but my question is, and I'm not suggesting this is the case in this case, but if a student is alleged to have committed a sexual assault, and he says that there was somebody else with him at all times and can testify what happened, if the fact finder says, I don't want to hear from that person, that's it, right? That person doesn't get to testify.
No, well, no, I would disagree, Your Honor. No. That would be preserved throughout the process, escalated up through the hearing, and then on the appellate process. And at
But it's an internal appeal. It's never externally determined, is it?
No, well, that's not true, because we are literally right now in the external review process, because Mr. Pattis is taking advantage of that through a Title IX lawsuit, which challenges the Title IX process now.
So let me ask you, if this was not a Title IX case, but this was a student disciplinary process for plagiarism.
I wouldn't be making this argument.
So because I'm concerned about the limitations of this.
I agree, Your Honor.
So let me give you another example. Connecticut has a very robust statutory scheme for condominium associations. And condominium associations can levy fines and foreclose on them. Would you say that the condominium association hearing process for determining fines would be quasi-judicial in nature?
If I'm not familiar with it, but if I may speak hypothetically, if that statutory scheme embodied the public policy of this state, some public policy, and then the statutory scheme required the condominium association to run some type of hearing in furtherance of that public policy, then sure, Your Honor, I think there could be made the argument that quasi-judicial immunity might attach to that proceeding. But you would need to step through what Your Honor just wrote, the paradigm in priori. And I think we meet that in this case, which is why Justice Ecker...
There's no transcript here, right?
There is a record, though. There's no transcript, but
there's no just please. There's no transcript, right?
No.
There's no oath.
But the oath is not required under a Petian.
Well, priori says that the oath is a procedural safeguard.
Understood.
Right? So there's no oath, right? There's no ultimate appeal to a judicial authority, is there?
There is, and that's what I just said. So as it escalates up, one of the things that Title IX allows is a lawsuit for a wrong outcome, a wrongful outcome, and that's what Mr. Pattis has at play right now in the district court. So he could also go, Title IX permits this too, he could also file a complaint with the Department of Justice Office of Civil Rights. So there's ample.
Let me follow that. The filing in district court. So is that like a motion to vacate an arbitration, similar sort of review?
No, it's a lawsuit. It's
to undo, and so what are the procedures?
So the lawsuit is filed, and in the litigation, what will be determined is if this process that we're all talking about was done impermissibly, and if it was, then they would argue they're entitled to equitable and relief and damages.
Okay. So in your brief, you make an analogy to arbitration. You're arguing that if we don't recognize the quasi-judicial function here, that this would undo arbitration or have an impact on arbitration. Do you see this as voluntary arbitration or involuntary, if you're making that analogy?
I see your point. So if I just understand correctly, your Honor's point would be that in an arbitration, the parties voluntarily consent to that process.
And then we know what the standard review is for it, or the parties bargain for, somebody not in a black robe to make this decision, and you get what you get. Are you making that argument vis-a-vis Mr. Pattis's client?
I think, though, that in a way, but I think that it's different than Your Honor poses, because when a student enrolls at Yale They're bound, but there's no negotiation. They're bound by these processes. So take, for example, a mandatory arbitration process with a private employer. There's no negotiation. You're not agreeing to that. You're bound by that. So I would say that's the analogy.
But that, I guess, so the analogy might not be perfect either way, because, I mean, if you go to college in America, you're likely to be sort of deemed to have voluntarily, I mean, I don't know if that's a contract of adhesion or something, but there's limits to that analogy that I put it this way. I'm not sure that this would have an impact on arbitration.
Well, I think my point at the end of the day is that if this court makes a black letter law that quasi-judicial immunity can never apply in a private setting, then it does have significant problems. It presents significant problems with private arbitration. And I thought, and I think Attorney Pattis thought too, that this court would be more concerned and most concerned with the safety that was at play at Yale to ensure the reliability of the process. And I am prepared to continue discussing what I think is...
I have one other question, but does anybody want to jump in? Sorry, I just want to make sure I'm not dominating here. But as far as binding, it being binding, is binding on Mr. Pattis's client, I take it he was expelled, your client, maybe she wasn't there any longer, that may or may not be her fault, but let's say she had a lawsuit against just anybody, it doesn't have to be her. A complainant has a lawsuit against the accused for assault. The outcome of Yale's proceeding, is that res judicata if he is not found to have been culpable? My question being, is it binding as to her? Is it binding as to the complainant? We know it's binding as to him. He's got some consequence.
Probably not.
Okay.
Probably not.
Thanks.
The public policy point that you make, is an important one in the sense that I don't think you'd get an argument from anybody on this panel that the interest in protecting, preserving, safeguarding, facilitating, a young woman's ability or a young person's ability to make a complaint of sexual misconduct on a college campus, is of great importance, rather than throwing up roadblocks, and even if we didn't feel that way, the legislature has told us so in this, statute, right? My point earlier was I think that we have to be a little more concerned than a private institution, perhaps, with the competing rights on the other side, and maybe that's instinctive just because of our, constitutional perspective in, criminal cases. But there's a lot of other important public policies, right, that are set forth in statutes. There's a lot of, and I looked at the mandatory reporting, some of the mandatory reporting statutes, and just some of the good faith immunity statutes. There's a bunch of them. And many of them have immunity provisions. They say if a report made in good faith, you're immune from civil liability. And 10A55M does not. And I'm just wondering what that means, the legislature knows how to do it. They obviously took great care in crafting this piece of legislation. And they didn't include a good faith immunity. Can you tell us, should we take any significance out of that?
I don't think so, Your Honor. I think they could have, for sure, as you point out correctly. But
is there any legislative history about why they didn't?
There isn't. There was an amendment, I think, as everyone is aware, in 2021 to provide a qualified immunity against the institution taking action against any student who makes a report who may be intoxicated or using drugs. So you can't get a double whammy. You can't get in trouble for using drugs. But they did not, to your point, the legislature did not decide to tackle that issue. I don't know why they could have, but I don't think it's of importance to this court, because what we're talking about is a common law, and it has not been abrogated by the legislature in this case, and I respectfully suggest it's this court's role to grapple with this issue.
But I mean, there's other statutes when they have dealt with the common law issue statutorily. So I don't know what to make of it. Which is one other question while I have on the qualified immunity. There is a qualified immunity or privilege in defamation cases for intracorporate communications, right? So if Yale puts in an employee's record, this person stole something, and the person gets terminated or whatever, or sexual misconduct is probably applicable too, and they get terminated, and there's a defamation case against Yale as the speaker. There's a qualified immunity under our law. It's not an absolute immunity. It's a qualified immunity. It would require Mr. Pattis, if he represented that employee, to show malice. Why shouldn't we? It's not about judicial immunity, but it's about a common law immunity or privilege in a defamation case that's targeted to, private employer conduct. Why shouldn't we apply that here?
Two things. First of all, we're not arguing that Jane is absolutely immune from everything that Mr. Khan alleged. And he alleged, for example, that she went around campus and said, Mr. This stuff. And we didn't...
I'm talking about in connection with the Tarosian and Gambardella are about statements made in connection with the employer's process, disciplinary process.
So in the process, I would argue, Justice Ecker, that there is such a strong public policy to bring forward underreporting victims of sexual assault. And it's we gave you the legislative history. It's so robust and so important that without that absolute immunity, you cannot carry out that public policy. And anyone who's practiced law and dealt with these type of situations know the first question you get is, can I be sued? And so if the defense ends up being a qualified privilege, you say, well, kind of, but we'll litigate this out. That's a stopper.
Well, the complainant can get sued if they make a criminal complaint.
So I'm not following what you're saying.
For vexatious litigation.
I don't recall what the case on that was.
Am I wrong about that? You can't get sued for vexatious litigation. Not vexatious litigation, malicious prosecution. It can be shown that you've brought a complaint, an official complaint, without probable cause. It's false. There's malice, which can be inferred from the lack of probable cause. You can be held liable. There's no absolute privilege for that.
That would be true, Your Honor. I don't think that would be the ultimate worry, though. I think the more immediate worry would be what we're all here with, which is...
But Mr. Pattis would have to show that it's false, that there's no probable cause, and that it was malicious. But you have to litigate it in a malicious prosecution case.
Those are... He'd have to win on the merits first and then bring that lawsuit. Those lawsuits are very few and far between.
Well, he did. He was acquitted. I mean, that's the law. So I guess this is coming to me late, but in a way, aren't you asking for greater protection for the Yale process than a person has for going to the police?
No, we're only asking for protection at the Yale process, no greater protection, consistent with what this court has done in its other quasi-judicial immunity cases.
Can you distinguish for me the malicious prosecution situation? How is that different?
This is the first I thought of that, and I'm
well, that makes two of us.
Yeah, I'm having some difficulty thinking through that. I'll concede it's an interesting point. I'd have to think more through that.
Does the university have to conduct a disciplinary proceeding such as the one conducted here under the Title IX requirements? Or in terms of supporting a complainant's ability to make a complaint, couldn't they do other things to satisfy Title IX, like support her with counseling, support her with help in going to the hospital, support her with help in talking to the police. Would that be enough, or do they have to actually have this disciplinary proceeding in place?
There are other
ways to encourage the reporting without necessarily going as far as it went here?
I think they're two different issues. I think
Because she clearly reported, she went to the police and she filed a criminal complaint.
I don't think you could, though, promise a complainant that there wouldn't be a hearing. There are some ways to mediate a dispute, but if it doesn't get
How do you mediate a dispute like this?
I'm following up on you. I don't think you can mediate a dispute like this.
Okay.
I was just answering your question. No, I think a case like this, in my experience, cases like this go to a hearing.
Counsel, let me ask you, this proceeding was a closed hearing, is that correct?
Not open to the public.
Not open to the public. Is that required by Title IX, that it be closed?
I couldn't say if the regulations require it, but my suspicion is they do, Your Honor. I wouldn't say one way or the other, though.
One of the things I'm struggling with is our Constitution says that all courts shall be open. And I'm trying to remember whether there are other situations where quasi-judicial proceedings are private and closed to the public.
I can't say that Craig, which is the police internal affairs investigation, was open to the public. I would highly doubt it was, but maybe it was. In Petting, which is the unemployment and security review process, which I've been involved in numerous of those are not open to the public.
And we've said that that's entitled to judicial immunity?
Yes.
Okay, thank you.
Off the top of my head, I can't think of another one off the top of my head.
Doesn't FERPA come into play with an educational?
Sure it does, Your Honor, of course.
So how much is prohibited from any disclosure with respect to these proceedings?
It probably answers the question right there, Your Honor. FERPA probably would require the proceeding be closed. Yale does have, and this is in the record, Yale does require confidentiality of these proceedings consistent with FERPA.
Okay, so who has to remain confidential? Not the accused and the complainant, or the accused too?
Witnesses, the accused, and the respondent, and the complainant. All participants in the process are required to keep the matter confidential.
And if there had been a record made, would that have been confidential too and not subject to disclosure?
Well, this is what I was trying to talk to Your Honor about before. There is a record. There's not a transcript. There is a record. And the panel decision is multi-pages, thorough, and there are minutes of the proceeding and a record of the vote. There's a record. It's not as though someone couldn't determine what happened. There's a record, a fairly thorough record. There's just not a recording or a transcript.
And is the accused going to be able to use that record, or is he?
Yes. And there's also, Your Honor,
in another court, in another proceeding? Or
Sure.
is there going to be a claim that that's confidential?
No, I'm sure Mr. Pattis will be using that record in the proceeding that's ongoing right now. And the fact finder report, too, part of the record, Your Honor, it's not in this record here, but if it were in this record, would be multi-pages long.
But the ultimate decision maker is not the panel. There's somebody above the panel.
Correct.
Who's that?
That would be the dean of Mr. Kahn's college. And the other thing, earlier it came up, one of the justices was, I think, skeptical of the partiality of the composition of the panel. Well, the UWC procedures, if I may finish, Your Honor, UWC procedures do contemplate that, and they allow for Mr. Kahn to challenge anyone who's on that panel who he feels is impartial. Thank you very much.
Thank you, counsel.
I've got a number of notes, and Justice Keller, the lack of a transcript, I think, is critical, and we asked for one so that we could record what actually occurred. We think it was critical because there were questions and lines of inquiry that Mr. Khan was unable to proceed or to pursue, and so he'll have to proceed by way of affidavit and recollection, and that'll be open to challenge, I suppose, but it would have been helpful to have something other than minutes kept by the decision maker. The question of malice and malicious prosecution, Justice Eckert, feeds into the confrontation issue. Critical to the defense, the successful defense of the criminal case, was our ability to challenge the witness's motive for bringing her complaint forward in the first instance. And that line of inquiry was limited at the hearing. It was highly controversial at the time of the criminal trial. I was the trial lawyer there. It was denounced in Time magazine, among other places.
But isn't that the problem, Mr. Pattis, is that, I mean, you'll give us, I think, just as a realist and as a person living in our society, an observant one, that there's a real policy problem. There is here, because if women, in order to make a complaint about something that's, extremely sensitive and personal, need to think about facing someone like you in cross-examination.
You hurt both my feelings.
Yes. I mean that only in the most positive way. But, a very vigorous cross-examiner who's going to get down to nuts and bolts in a take-no-prisoners manner. I mean, that's a strong reason not to bring a case, and that's their whole point.
No, but I think there's a quick fix, and that is an indemnification agreement, which would give Yale a stake in fair procedure. I will say, young lady, if you bring this action, you won't be sued, and if you are sued, we will stand behind you. We'll finance your litigation. We'll pay any damages. But look,
well, Yale, after all, is the one that makes the policies. I mean, the procedures. It's strange to hold her hostage in a way to the fact that Yale decides not to allow cross-examination and all these other things. Again, not criticizing them. Maybe that's smart from their perspective, but she is in quotes, victim of the policies and procedures that the university adopts.
Justice Ecker, I will concede that the policy rationale for application of immunity is the strongest argument in favor of it, because of the reasons you cite. Having said that, that's not the only factor. And in our view, Yale succumbed to a form of malice of all of its own, and adopted a set of procedures that was so stacked against a young man engaged in what he regarded as casual sex that night, that routine campus behavior was criminalized. He was, expelled from the university, exposed to the risk of death if he has to return to his native Afghanistan because of his family having been targeted by the Taliban. So, I mean, I understand the policy rationale that support the need for young women to come forward. I understand the imperatives of the Me Too movement, but I also understand the very real world that my client lives in. He was recruited from overseas to Yale, sent to prep school, recognized by his preference, brought to the university, engaged in conduct that is far too routine on that campus, a campus that dispenses condoms down in the basement in a laundry room in case kids have to do something while their laundry is drying, and then submits him to little more than a kangaroo court before it throws him on the street.
Counsel, let me ask you, did the university take a position in the district court on the motion to dismiss?
I'm embarrassed to say I don't recall.
I mean,
I didn't even check that.
I find it pretty astonishing that Yale isn't here to defend its own process. So I'm just trying to figure out why the stakeholder with the most at stake decided to take a pass on helping us resolve this issue.
I don't want to speculate. With your permission, I'll check the docket sheet and write a letter to you. I'm embarrassed to say I didn't check that.
No worries, I'll check the docket sheet.
Mr. Pattis, Attorney Sconzo referred to one of the procedures, one of the checks that you have available to you is a district court action attacking the fairness of the proceeding. Is that this lawsuit?
Yes.
It is this?
Yes.
So this isn't purely defamation type of action? It's an attack on the proceeding itself?
Yes, and while we're in court, we brought a related claim that arose from the same transaction.
Against her?
Yes.
Okay, so the one against Yale she's not a party to that action?
She's a witness, but she's not a party, technically speaking.
I got you. Thank you.
But she was in our view, she was going to be involved in the proceedings, and so we pled the cause of action because we're already in the fight.
I guess my final concern is that one of the factors to talk about a priori is that the hearing officer, the person, whoever's hearing the case, applies the fact to the law to the facts. That has to be done. And here, they take some fact-finding from an independent fact-finder, possibly someone hired by Yale, and there was a mention that the panel will decide whether to call a witness and does so only if the witness can offer potentially relevant information that was not already conveyed to the fact finder. So there's no crucible there for the testing of credibility. Really.
It's a struggle session. I mean, you're brought into a bunch of people, in my view, who've largely prejudged the case, and you plead for your life without counsel and without the ability to confront the witness. The witness was there by way of video. Mr. Khan was not even permitted to be in the room as her image was displayed. And I just can't, I've done a lot of cross-examination via Zoom in administrative hearings. It took some getting used to during the pandemic, but not once have I, and nor would I ever, stake my client's liberty interest on a mail-in cross-examination. I want to be there so I can sense the witness's emotion and energy as I cross-examine. You can't have that without. One final point. This goes to a point that Justice McDonald raised, and may I?
You may.
What Attorney Sconto is arguing basically a facial thing. On its face, this policy is perfect. There's nothing to complain about. Our challenge is as applied, and we believe that until we've had a chance to air that, quasi-judicial immunity ought not to apply to Jane Doe. Thank you.
Thank you, counsel.